Hey, what's up you guys? Welcome to my channel. I bet that you don't know who John Marshall is because he is one pretty old dude. Well, if you don't, you're in the right place. John Marshall was most recognized for establishing judicial review in the Supreme Court. John Marshall was born on September 24, 1755 in Germantown, Virginia, and was the eldest of 15 siblings. His parents were Thomas Marshall and Mary Randolph. His father made a steady income, and his cousin Humphrey Marshall became the senator for Kentucky. As a boy, John Marshall was mainly homeschooled by his father. Then, he attended 1 year at Campbell Academy where he met his fellow classmate future President James Monroe. He served in the Revolutionary War, which put his studies on hold, and then left the militia in 1780 to study law. He went to get his degree of law at the College of William and Mary. After John Marshall finished his studies at the College of William and Mary, he was admitted to the Virginia bar. After he was admitted to Virginia bar, he began his own legal practice. His practice was built on defending clients against British creditors. He was so successful that he was chosen as lead counsel for Supreme Court of the United States case. His government career began by him representing Fauquier County in General Assembly for one term. Then in 1782, 1787, and 1792 he served in the Virginia House of Delegates representing Henrico County. He ran for city council in 1785 but came in second place. In 1788 he became a delegate of the state convention. John Marshall was invited to join the U.S. Supreme Court in 1797 but turned down the position to help them out in France with the XYZ affair. He was elected to a seat in the United States House of Representatives in 1799. He was appointed by John Adams, commissioned on January 31, 1801, and was sworn in on February 4, 1801. John Marshall's seat was seat number 1. These are some of John Marshall's landmark cases. Marbury v. Madison was a case that established the court's power to review the constitutionality of congressional acts. McCulloch v. Maryland was when the state of Maryland imposed a tax on the national bank, which the bank refused to pay. And finally, Keynes v. Virginia was when the Cohen brothers, who sold Washington, D.C. lottery tickets in Virginia, appealed their conviction of having violated Virginia law. John Marshall was both English and Welsh. His religion was Episcopal, and he was distantly related to Thomas Jefferson by his mother's side. John Marshall passed on July 6, 1835. He was 79 years old and died of an unknown illness in Philadelphia, Pennsylvania. The Liberty Bell was rung during his funeral procession. Did you know about the Supreme Court case on same-sex marriage? Obergefell v. Hodges. James Obergefell was the lead plaintiff in a Supreme Court case that would legalize same-sex marriage across the United States. The lead defendant in the case was Richard Hodges, a former member of the House of Representatives and at the time the director of the Ohio Department of Health. The case was first granted on January 16 of 2015. It was argued on April 28 and decided on June 26 of the same year. This case took place in the United States District Court for the Southern District of Ohio. In this case, all 4 of the court's most conservative members wrote separate opinions. Justice Scalia called the decision a threat to American democracy, saying it was constitutional revision by an unelected committee of 9. The case ended with a 5-4 decision. This case opened marriage legally in all 50 states and gave new legal protections for those who got married under court rulings. Those whose marriages could not be considered truly final until the Supreme Court had decided this case may now finalize their matrimonial unions. Some arguments made during this case were that same-sex families are deprived of the status, dignity, and material and legal protections that marriage brings, solely because of their sexual orientation. Bans on same-sex marriage should be subject to heightened scrutiny because sexual orientation is a classification just like gender or race. Sexual orientation is an unchangeable characteristic that does not affect an individual's ability to contribute to society. Queer men and women have historically faced and continue to face severe discrimination in more than half the states which have no protection from employment or housing discrimination. Banning same-sex marriage does not support procreation or the raising of children. Many opposite-sex couples are unwilling or unable to have children, but these states still allow those people to get married. If married parents are better for children, same-sex couples' children should get this benefit. This case went all the way to the Supreme Court because the bans on same-sex marriage were unconstitutional. It was a violation of the Due Process Clause and equal protection under the 14th Amendment. The 14th Amendment states that no state shall deny to any person within its jurisdiction the equal protection of the laws. This case had a great impact on American society. The decision had nullified bans on same-sex marriage as well as bans on official recognition of such marriages performed outside a state. Same-sex spouses now had the same rights and benefits as legally married, opposite-sex couples, including tax relief, emergency medical decision-making power, access to domestic relations laws, spousal benefits, inheritance rights, and spousal testimonial privilege. I hope we gave you enough information for your test coming up. Thank you for watching. Don't forget to like and leave a comment down below. Subscribe to Jennifer for more amazing content. Love you, bye.